Welcome, everybody, to another episode of the Cross Country Super Podcast. Lovely to have your company with us. And of course, I'm joined by Jemma Sanderson over in Perth,
Hi, Darin.
who's always with me to put these podcasts together. How are you, Jemma? It's great to see you.
I'm good, Darin. It's sort of, when we're recording this, the lead up to Christmas. So it's equal parts hectic and people starting to ease down. So trying to get all that momentum happening.
Yeah, I'm just trying to get to the finish line of 2024, to be honest, Gemma. I'm like a marathon runner, staggering, staggering towards that point. I can see it, but boy, my legs are
Oh,
like
your
lead.
legs are giving way. Yeah,
Yeah, they're
I
like
hear you.
lead
I
now.
hear you.
I'm starting to run on the spot on one blade of grass now. I'm just running on the spot at the moment. So just trying to get there, but we'll get there. Anyway, enough of our woes.
Yeah.
Today, we're going to talk about a fairly significant case that happened in the SMSF world. It was
Yes.
pretty recent, wasn't it?
Yes, it was.
And,
And I can think it was in September. There you go. So
yep, yeah, that is pretty recent, even
yeah.
before the footy season finished. So that is recent. And it's the commonly referred to as the Gainer case. I don't have the actual official reference to what the case number and the case reference was, but it's commonly referred to as the Gainer case, and it looks at a whole raft of issues to do with estate planning and some of the nuances and challenges, I suppose, when a situation occurs that people weren't quite prepared for it. And then, of course, as we see in a lot of cases with estate planning, it opens the door then for, oh, well, maybe I can challenge that this wasn't done right and that wasn't done right. Because, as we keep saying, litigation in this area only continues to build. It's certainly not
That's right.
getting less. And that's not coming from my mouth. That's coming from the mouths of people like Peter Bobbin,
Yep,
Scott
that's
Hay
right.
Bartlam. You
Mm.
know, they're at the coalface of these issues. Dan Butler. They're representing people in some of these cases, and their caseload is building as far as this goes. So these issues
Well,
are
in
very
fact, Cooper and
important.
Grace Ward were involved in this case. I can see
Oh,
it
well,
on
there you
the
go. I mentioned
yeah.
Scott Hay Bartlam and Cooper Grace Ward.
Yeah, that's right.
Where he works, they were involved in this. So it's getting more and more prevalent, and of course, with capacity issues and mental well-being, that sort of thing, more and more sort of crevices are appearing where people are looking to maybe drive a small wedge through to see if they can take advantage of some of these situations and, of course, test them in court. So again, there will be and there will continue to be landmark cases which draw out, what a possible scenario might be and what the outcome will be, and of course the lessons to be learned from that. But
Yep,
Gemma, I might
100%.
just hand
Yeah.
over to you just to take us through what the facts of this case were.
Yep. Thanks, Darren. This one was really interesting to read, but by people like me who love to read this sort of stuff, and like really instructive for the industry as well in terms of how we might have discussions with our clients about their estate planning, the importance of again some nuanced items such as what is the definition of a self-managed super fund and how that flows through. So we'll touch on those as part of today's session. So just a little bit of background as to what happened here. So Gainer was the name of the trustee company. It would appear to be a combination of the husband and wife, their names when they set it up. Trustee of the self-managed fund, he subsequently died, and she was then the sole member and the sole director of the trustee company. So her name was Ms. Thielen. So there's quite a few names in here. So if I say her, that's what I mean. So just to make it easier from that perspective. So after her husband died, she went on a cruise at some stage, it wasn't immediately after, and she met a chap called Mr. Bone, and he was from America. and he was actually, funnily enough, an estate lawyer over there. They met on a cruise, and then they kept in contact subsequent to that particular cruise. Then she got cancer and she died, and she appointed her. So the executor of her estate was the New South Wales trustee and guardian. Her and her husband had no children, so her estate was, or her will was drafted, where Mr. Bone would receive $1 million, her car at the time, and a life interest in her property in Clontarf. So that was basically what her will said, and the balance was to go to family members, so nieces, nephews, brothers, sisters, etc. Now, she did have a binding death benefit nomination in her self-managed super fund, but it was not binding because it was only witnessed by one person. And that paid all of her benefits to her estate. So that was sort of a bit of the background there. Now, with respect to the super fund, the New South Wales trustee and guardian, they were the executors. So when you have a look at the definition of a self-managed fund under SIS Act Section 17A, it allows for the executor of a deceased member to step into the shoes of that member and act as either the trustee or the director of a corporate trustee from that perspective. Now, that was a real challenge here because the New South Wales trustee and guardian is not a person, it's an organisation. And so if you can't, even if you nominated someone from within that organisation to step into that role, you're still technically in breach of 17A if that doesn't get dealt with within 6 months of her date of death. So what the trustee and guardian sought to do was to appoint an independent person to step into that role. And that was a chartered accountant whose name was Mr. Heesh. So Mr. Heesh was put in that role to act as the trustee and effectively look to pay out the death benefits and wind up the fund. So he was appointed in that role. And at the time, they went to the tax office to basically acknowledging, look, 17A is going to be breached. And so therefore we really want to deal with these benefits as soon as possible, but we don't want the fund to be made non-complying. And the tax office, the commissioner gave them an indemnity to say, if you sorted it all out by November 2024, we won't make the fund non-complying. So that was quite a good outcome from that perspective. Anyway, then we transplant back to, okay, Mr. Heesh needs to do what he needs to do as an independent director or trustee here. And so with a non-binding or a death benefit nomination that is not binding, then trustee discretion takes over. So he then accepted submissions from any potential beneficiaries about how that benefit is then dispersed. So Mr. Bone made a submission on the basis he was a de facto, also that as a dependent, he should be the person that the benefits are directed at, because from a tax perspective, as the dependent, the taxable component would not be subject to tax. And then, of course, the New South Wales trustee and guardian made a submission on behalf of the beneficiaries of the will. Mr. Heesh went through quite a long process assessing all of the merits and the like. And that was, when you read through the judgment, you can see there the consideration of a lot of time spent on his timesheets and things like that. And ultimately, he landed on a decision of 1/3 of the super to Mr. Bone and the balance to the estate to then be dispersed in accordance with the will. So Mr. Bone didn't like that decision. He felt that it should all go to him. So that was one of the considerations there. And then the other one was, so Mr. Heesh was an independent director, but can he charge for his services as that independent director? So that was another area to unpack, because SIS Act 17B says that trustees can't charge for their services to act as a trustee. So you can see there's a lot going on, unless it's in their professional capacity of, so this is where we've got that, I'll call it a Goldilocks approach a bit. 17B prohibits a trustee for charging for their services, but then the non-arm's length income or non-arm's length expense provisions in the Income Tax Assessment Act 97 295 550 prohibits you from not charging for your services if you have a professional sort of hat that you're wearing, like the accountant, the property manager, the financial advisor, the lawyer on behalf of the fund. If you don't charge for those services, then you can be caught under the non-arm's length expense and therefore non-arm's length income provisions. So as you can see, there's quite a lot of little bits and pieces to consider in there and lots to unpack, which is, again, for the industry, quite instructive in terms of how we guide our clients on various issues and the practical side of things. So where I look at these things, I think, okay, well, you could achieve this in this manner, but I call it the faffing around factor is substantial. Is it really worth it? And so in light of that as well, okay, well, what is at risk? What are the risks here if this is what happens? And maybe you just take those risks on board. So I'm talking here on the consideration of leaving benefits perhaps to a de facto rather than allowing for them in the will, how all of that interacts from that perspective. So yeah, lots going on there, lots going on. And I didn't give you the final bits
Well,
and pieces because we'll address those as it
that was
happens.
that was a fairly comprehensive summary, and so many things going on with that case. Boy, oh boy. Um, I can imagine if you're faced with that, it would be a matter of where do we start? Seriously,
100%.
where do we start?
And it's only a 23-page judgment too, which is
Oh, that's actually not a bad result.
yeah.
Yeah,
Yeah. Yeah.
yeah,
But
that's
yeah,
not
lots unpacked.
that's certainly not a horrendous amount of documents to wade through if you're looking at this case. But I thought I might go right back to the start. If we're looking at lessons learned, and of course, with all of these cases, which can be seen as precedents, I suppose, for situations into the future. If we go back to the start, it probably highlights right at the beginning when the spouse died or the remaining member died as to the difficulty that may arise when you don't plan for this this type of
100%.
situation, as in it's all very well, and you must see this all the time, and I know that probably the majority of SMSFs are structured like this. It's husband and wife, you know, for want of a better term of that relationship, and it's always assumed that, oh well, one of us will pop off first. So if I pop off, then my wife can be the sole member of the SMSF, and off we go, and the fun continues, and she can run it, and whatever. We always kill the husband off first, don't we? It's
Here we do. Yep.
rather convenient. But then again, women do live longer as far as the average age expectancy goes. So we're only playing into that narrative. Anyway, but of course, what happens then to the spouse, because she's the sole member? It's not like she's got to get out of jail free clause to say that, oh, when I pop off, there's another person to take it over. And this situation probably highlights it. It's like, yeah, I'm sure they obviously thought of the first contingency when one of them kicks the bucket first. But what happens when the second person kicks the bucket? And this absolutely highlights it in Technicolor, doesn't it?
Yeah, it does. And I think that again, like those are the big considerations. Is unfortunately we are encountering more widows and widowers coming through. They're sort of over 70. They're looking at, okay, well, now it's just me. I'm the sole director, sole member. So that ticks the box in terms of the requirements under the super legislation. But what happens when they die? And if they don't have children, so in this case, they didn't have children because invariably it sort of makes sense that the children step into those roles. But you've also then got to be careful about how you might engineer that, because if you said, right, I've got 3 kids, dad's died, mum's left over, let's throw the 3 kids into the mix. Well, and you've got to revert back to what does 17A say about that? So if you're a member of the fund, you've got to be a director or a trustee. If you're a trustee or a director of the corporate trustee, you have to be a member. So then these kids all of a sudden become members of the fund, or maybe you've just picked one of the kids. So if it's just one of the kids, then if it's just one, it's okay because you can have 2 directors in there and with a sole member or two trustees in there with a sole member fund. But then you've got those risks with, well, what if the binding nomination isn't binding and valid, like in this case here, and then it rests with the trustee to exercise that discretion. Now, you don't have to justify or show your reasons for the exercise of that discretion, but we've seen that case, the Marcella case, which was a self-managed super fund one, and then a family trust one, Owies, that showed the importance of being aware of who the potential beneficiaries are and making sure that any discretion that's exercised is in a fair and reasonable manner. Again, you don't have to justify it, but if it's, so in the Marcella one, the daughter paid all of mum's super out to herself on the basis that mum wanted it to go to her grandkids, but she failed to acknowledge that she also had a brother who had kids. And she had a fractious relationship with her mum's partner at the time. So it, all of that came to the fore of this fair and reasonable manner. So with that, like, there's those sorts of elements in mind. So back to your, we digress easily. It is really important to consider who's going to step into those roles. Do you just rely on the executor, which is obviously what happened here, because Miss Thielen had she had siblings, she had other people in her life that could have stepped into that role as an individual, and if it was her siblings, if you have a look at how you can pay out a benefit on death under the SIS regs 6.21, you can only pay it to a SIS dependent or the estate. So a sibling, unless they're financially dependent on you, is not an eligible beneficiary. So you get that element of independence. So that's a really, really big decision and consideration there. And before you jump in again, the other thing with that is the requirements under SIS are all about who's the director of the fund, not about who the shareholders are. So within that company, you can manage some succession elements there by, say, mum's the director, but the mum and the kids are all shareholders. So if something happens to mum, the kids can, as the shareholders, can step in and appoint new directors. And even though it might be that they're not the executors, and so therefore 17A is a consideration, if they can deal with mum's benefit within that 6-month period of time after mum's death, then you can manage all of that. So it's worthwhile not just going, it's the directors. Who are the shareholders? Do you put in place an automatic succession if mum or dad is incapacitated or dies, that particular children or others, even independents, are automatically appointed into as directors. So there's many elements that you can look at to try and manage that situation.
Yeah, well, that was a point that I was going to raise. You read my
Sorry.
mind, actually,
Yeah.
Gemma. That and this has probably been more recently discussed, more commonly, I suppose. But this whole in legal circles talking about the appointment of a successor director
Yep.
straight away. In it doesn't have to be obviously uh, in the event of death. Again, it can be in the event of somebody losing their mental acuity to be able to run a fund. But this whole concept of appointing a successor director is starting to play more into the narrative now.
Mm,
So obviously that
definitely.
is one solution that may have uh, lessened, I suppose, any sort of angst everybody had with dealing with this situation.
Well, definitely. It still has that element of, so who is that successor director? So you can put in place documentation within the company that says if Jemma dies or becomes incapacitated, you can even have a definition of what incapacity means rather than the person having to be deemed by, so in WA, it's the State Administrative Tribunal, but every state has their equivalent. So Gemma's been deemed to have lost her marbles. So that's when the person steps in. You can have your own definition in there if that's how it works. And then they're automatically appointed as a director. You then have to be, so what are the practical implications of that? So that's notifying ASIC as well. Do they have a director ID that you need to
Oh,
factor in? Like,
that's a great point now.
yeah,
Yeah.
so all of those sorts of things to make sure there's no considerations there. So again, that practical side of it. And then we revert back to, well, the legislation under 17A says that the fund can continue to meet the definition of being an SMSF if their directors in a trustee company are the enduring power or the legal personal representative. So the person is incapacitated, that would be the EPA. But what if you're appointed, but you're not the EPA? So making sure that that gets covered off as well. And it might be, okay, well, mum's lost her marbles. The kids have all stepped in, but actually one of the kids is the EPA and another child or something. And it's looking. You really need to be clear on all of what the documentation says from that perspective.
Yeah, it's never an easy thing,
No.
and it is so important. Again, another thing highlighted you mentioned in this case, it is so important to get your documentation and your procedure right. I know it's a pain. Nobody
Yeah, it's
likes
painful.
procedure.
Yeah.
No one likes administration, and certainly not administration, which you would probably consider that, oh, really, Gemma, do I have to
Mm.
do I have to do that? Do we have to go to those lengths? But look at this case. The binding death benefit nomination wasn't properly witnessed, which
Yeah.
meant it was null and void. I mean,
Yeah.
and of course the danger there is that I'm sure that the spouse in this case would have been operating like carrying on as if, oh yeah, it's all
Mm.
right. Got a binding death benefit nomination in place. I've actually done my homework on this.
Yeah.
We're right to go. If I pop off tomorrow, it doesn't matter. I've got these things in place. But yeah, without crossing the I's and crossing the T's and dotting the I's properly, you actually don't.
And I think that's highlighted like a lot of what we encounter, and I'm sure all the lawyers would agree as well, is that a binding death benefit nomination. And you're right, people have that confidence. They're like, I've gone through my estate planning, I've got my will, I've got my binding death benefit nomination. It does all these things, but then you have a look and you read it, and it hasn't been executed properly. It hasn't been accepted by the fund in the way that the deed requires. So again, all that documentation and binding death benefit nominations can just be a single page. Like they don't need to be, and often aren't, big, lengthy, like wills can be more comprehensive, but a binding death benefit nomination often isn't like necessarily a substantial document. So, but a few words that are incorrect, the witnessing isn't done correctly. What does the deed say about it all? And we're encountering, and I'll digress a little bit here, with deeds, that whole chain of deeds. I think I've spoken about it in previous podcast. Although we were saying earlier, we're not sure if we're Arthur or Martha on who we talked to about that. But anyway, that chain of deeds. So we've encountered a number of deeds in recent times that have got a principal employer in them. And then looking at the chain, then this principal employer has just dropped off or dropped out. And all of a sudden, you've got, well, are the subsequent deeds even valid? Because often the principal employer needs to be the one that's also approving or endorsing a deed amendment. Or if the principal employer no longer exists, then the trust, being this fund, has to vest. And so we've got one at the moment where we're considering that it's got a principal employer in there. Those sorts of clauses are there, and the company was deregistered 10 years ago. So all of a sudden, there's these real issues. Do we have a subsequent deed that was executed properly that can actually cover off on those? All of that sort of stuff. So that documentation is unbelievably important.
Oh, I couldn't agree more. I know it's not a sexy subject when you're talking
No,
about
it's not.
SMSF, and no one thinks that administration is a great subject to have to talk about and to be really fastidious about, ensuring that things are done properly. But this situation is only going to get more urgent, I suppose you could
Mm.
say, and more important because we're now delving into the realm. Again, I go off piste a little bit here, but we're
Yeah.
now delving into the realm of electronic signatures and
Mm.
electronic approvals. And you might think that, oh, what are you talking about, Darren? That's just a matter of just approving something. You know, you're doing this on Zoom right now. You're adopting technology. It's just an extension of that, isn't it? To help us break down boundaries and make things more efficient. Yeah,
Yeah.
but is it? Because, you know, there are situations, anecdotal situations I've been told of, is where people have approved something over Zoom or electronically, but was the camera angle wide enough
Mm,
to show that there was actually a second? It might have been when the original discussion was taking place, but when the actual documents were signed, was the camera angle wide enough to encapsulate how many people were in that room and whether or
mm.
not another person actually saw the signing of the
Yeah.
document? It sounds really
Or
trivial.
was there some coercion in doing
Yeah,
that? All
that
of
that
those
you
sorts of
can't see
things.
off
Yeah.
screen.
Yeah.
And I know that, I mean, you might think that, oh, Darren, you're just making this up, this stuff up. I mean, but I mean,
No, you can't make this stuff up. You can't.
again, anecdotally, I wouldn't raise it unless I've been in forums where this has actually been discussed as to, well, we can't have certainty as to whether or not was it witnessed properly. We can only
Mm,
see you on the camera at the time. I know when it was all agreed, there were three of you, but when the document was signed, we could only see you on the camera. We can't see whether or not back conversations are going on while
mm.
this is being done. So there is a whole myriad of stuff which is probably about to come to the surface as we adopt more technology in trying to make these administrative procedures a little bit more streamlined. Bit
Yeah.
ironic, that.
Well, we hate life admin. Like life admin does suck, but it's really important. So a bit like here, if it had been considered her succession in that company, and perhaps it was her brother that stepped in, even as the successor, he didn't need to be the executor necessarily. But then, that might have meant that the fund could continue on. It might have meant that they didn't need an independent trustee that had to go through that process. If the binding death benefit nomination was executed properly, then that claim staking process that Mr. Heesh had to go through to say, does Mr. Bone get anything? Or do I just go, look, there was a non binding nomination, pay it all to the estate, and then the estate can deal with it all? All those sorts of things. And that's like that was, I think, the final costings for Mr. Heesh was nearly $100,000 worth of fees that he was charging there, and that's a whole other thing, obviously, that we were going to talk about, and perhaps now's the time to sort of address that bit.
Yeah,
Um,
and it's again, it's another relevant point, Gemma, because you might say that, well, you know, doesn't really matter. These situations tend to sort themselves out in the end, and I suppose in this case, we're really talking about, in the context of things, a fairly expedient solution to this. I mean, these things can go on forever,
mm,
really, and of course, the longer they draw on, the more fees are involved. And of course,
yep.
what does that do? I mean, Mr. Bone in this case might be wanting to say that, hey, I want I want the entire piece of the pie. I don't just want a little portion of it. But by the time you contest and contest and contest and contest and
Mm.
contest, how big's the pie going to be in the end? And
Well, and when you look at all the lawyers involved as well, um, so obviously not a small estate, but that gets whittled down reasonably quickly when you're looking at these sorts of things. So it's like our role as advisors is to try and mitigate you being the next Gainer or the next Marcella or the next Hill and Zuda or that sort of thing. So because and the lawyers can slap me across the face later, the only winners in these sorts of cases are the lawyers.
no, and they readily
Yeah,
admit that. And you're
yeah,
absolutely right. I would die if my name was ever on one of these iconic cases
yeah,
to
yeah.
say that, oh, this represents a situation where, you know, you should do this or you shouldn't do this. Or I don't want anything to do with it. I don't want my name on there. I don't want to be a Cats versus Grossman or anything like that.
No,
Don't want my
no,
name to be
100%.
associated with any of those sorts of things. But again, we digress. Let's go on to the guy who was appointed to
Yes.
do all this stuff.
So there, and I briefly touched on it earlier. So you have to have an individual in the role as a director or a trustee. So they appointed this chap, Mr. Heesh, and then for his role as trustee under 17B of the SIS Act, you're actually not allowed to charge a fee to the fund for your role as the trustee. But then he was also performing some elements on behalf of, like as a professional. So there was those two sort of lines or lanes that he was swimming in, and which one fell where he had to, where, well, obviously he wanted to recover all of his fees, and where did it fall from that perspective. So and the trustee and guardian had acknowledged that and said, well, you're an independent. 17B kicks in and sort of says you can't charge for it. But you know what? If that's how it's determined, we'll just pay you out of the estate. So they, come to the party, because otherwise, who's going to ever act in that sort of role?
Well,
Because
you
they're not
wouldn't.
getting paid for their job,
Oh,
right? Um, so anyway, so that sort of went through. Now, ultimately, the uh, the professional fees charged in the lane where you were acting as a professional, that was okay, but on the lane when he was a trustee, he was unable to charge for it, and in fact, even the estate couldn't pay him because 17B effectively. In summary, says the fund can't pay you, but neither can anyone else for you to act in that capacity or in that role. So, a real issue there, because maybe that was about $60,000 worth of time.
yeah,
I'd have to double check exactly what it was, but not insignificant. And especially if for him and his business, that's a substantial chunk of time.
yeah,
Ultimately, the outcome was, look, these are how the rules work. 17B says you can't charge for it. So no, you can't be paid for that. And the executor and the estate also can't pay you. However, because of the indemnity that the fund had been granted by the commissioner, that they wouldn't make the fund non-complying if it got dealt with by November 24, then they allowed it effectively, because there wouldn't be a breach of 17A by having Mr. Heesh in there when he wasn't the executor beyond the 6-month period of time. And likewise, they considered that that under 17B, he could charge that fee to act as the trustee. So again, it highlights just how those provisions operate and how impractical they could potentially be in some situations like this one. And then back to, well, Ms. Thielen, who should you have appointed as your executor? Should it have been the trustee and guardian, the New South Wales trustee and guardian? Is there someone in the family or elsewhere that can take this on, where you're comfortable, or that they might be comfortable that they're not going to be paid in that role? But it's just to wind it up effectively. This is where children can be helpful, because if they come into that role, they're often the beneficiaries. Sometimes they might even keep the super fund and join as members themselves and keep things churning on. But it is a real consideration there.
yeah. I just think well, I'd like to note that the ATO actually did exercise quite a bit of pragmatism here
Mm, very much so.
to try and get the outcome, and that's probably one of the misconceptions that oh, don't tell the ATO because it'll be bad for us. A good illustration of how, yeah, if you're straight up with them and you try and offer a solution, like a practical solution, they can come to the party and
Mm,
get a better resolution for everybody, because I think they've stated over and over again the last thing they want to do is to have people lose their retirement
yeah, lose
savings
it. That's
because of
100%.
these things just drag on.
Because of a procedural element.
Yeah,
That's right. Yeah.
exactly. And number two, I suppose, Gemma, looking outside of this case is obviously all about estate planning and the challenge of a will and death benefits, but this whole principle of what you just talked about actually goes beyond just an estate planning context. I mean, isn't that whole grey area of what you can charge for and what you can't charge for in terms of acting as a trustee or potentially not acting as a trustee, performing services for the fund? That's
Mm,
what all the non-arm's length expenditure stuff is
that's
about,
right.
isn't it? I mean
That's
that
100%. Yeah.
I know it's not linked. This isn't about gnarly with an E, but the whole principle, in a nutshell, that's it, isn't it?
Well, that's right. And so that's definitely a consideration, like that. I say that Goldilocks approach in lining all of that up. It is important in this situation. So in this case, it's slightly different because obviously it's not, the person isn't a member, but you can see where you've got a member or members and they can wear those multiple hats. You do have to land on that situation. Okay, what is a trustee service that we can't charge for and don't want to charge for, but what is a professional service that we have to charge for? Otherwise, we could end up tainting. I mean, the way that the non-arm's length expense for general expenses has come through is now borderline immaterial. But what if it's property management for a particular property and you're not charging an arm's length fee? Those sorts of things. So I think it's really important to be aware of how those provisions do flow out.
Yeah, absolutely. And at least I suppose there was, could I describe it as a fairly neat delineation in this case?
Mm,
The line probably wasn't as grey as it can be in some areas. So, but again, nothing's going to test these parameters apart from case law
that's
and
right.
decisions like this. As terrible as that is, nobody wants um, elements of the superannuation system to be tested in court, but it's really the only way that you can actually establish what will happen in certain situations. And
That's
in this
right.
case,
Yeah.
it was pretty fortunate that it was a fairly easy distinction to make. It wasn't very grey. That by the sounds of it, they could easily say that, well, when you did this, you were acting as a professional. So
Yeah.
that's all right. When you did this, you're acting as the trustee. So no good
And
on
I
that.
think a lot of that was down to when you're assessing who the potential beneficiaries are, what their that justification, that claim staking process, that would have clearly been as a trustee, assessing perhaps the tax implications of it. That would be from a professional, like you could, again, like you said, delineate what that looks like. And also with your other point, the tax office is very pragmatic on these sorts of things. The 6 month time frame that you have to deal with this, that is like that goes through like that when someone dies, trying to deal with benefits. And then if you throw in an estate dispute, and then we encountered one where it wasn't until probate was granted. We had two competing wills, one that was signed and everyone was like, yep. But then there was a subsequent one. And the argument was, well, did the testator have capacity to sign that? So that's what it all looked like. That took 2 years to resolve. So we're
Yeah.
sort of sitting there in limbo of who is the trustee or who's sitting in the fund on behalf of the member. Is it the wife who was the first executor of the first will, or was it the daughter who was the executor of the second will? That was then they were then trying to figure out whether that whether the chap had capacity at the time. So then you're sitting there with this company that might not be satisfying the requirements of 17A. And actually, there was another case, I think it was Williams in recent times, either Williams or Dawson, where they had the enduring power of attorney over the period of incapacity of a member was a particular person. And then when the person died, that the power of attorney stayed in the role as the director on the expectation that, well, you're the power of attorney, you're probably also the executor, so we won't update that directorship. And then years later, it was sort of determined that actually he wasn't he wasn't the executor. It was a different legal personal representative. So then, oops, we've had the wrong person in there. They tried to backdate it and all sorts of things going on. So anyway, it's again being aware of how all of that interacts and then being able to convey, like, is there a risk there from kids trying to disinherit their siblings, a spouse trying to disinherit the blended families here, the kids from the first, second, whatever, third marriage. What are all those risks looking like, and how do we manage them as much as possible?
Yeah, so difficult. And again, that's another great point you raise. Gemma, around realistic time frame expectation with a lot of these issues. Oh, I'm not talking about this case in particular. That seems to have been resolved in a fairly timely manner. But when you hear discussions around death benefit pensions and reversionary or non-reversionary, and
Mm,
you always have this term paid out as soon as practicable.
yeah. Yep.
And of course, the next question that comes up is, well, Gemma, what's the definition of as soon as practicable? Practicable. God, try and get your mouth around that.
I know, right? Yeah.
I'll put my teeth back in a minute. And there tends to be a bit of a rule of thumb if people are pressed on it to say that probably 6 months is seen, as the rule of thumb. Don't be bound by that, but potentially, if you want a guide, that may be. But it may be heaps longer than that.
Much longer. Yeah.
And you might think that 6 months, that's reasonable. Even 12 months, you might think that, oh yeah, I can sort that out in a year. But in the
That's not
time,
very long either, a year
correct.
in the
In the
scheme of
time
things. And I'm
frame,
just
yeah.
having a look here. So Miss Thielen, because I've got it all in front of me, she died in, it looks like around April 2021.
Okay,
So
so
it was, 3 years, 3+ years before any of this really got dealt with. So it's, that's and you see that in some of these cases where it is 3 to 4 years between death and the actual judgment. So the whole consideration there is making sure that you're not the subject to one of these, because particularly if you need the money, um, and it's going to the lawyers and not to you, then for you to live, then that's a real challenge.
oh yeah, absolutely it is. And again, it highlights that the individual probably thinks that, it'll be all smooth sailing when I'm
Yeah.
gone. I don't want to create any hassles. I've told you what I want to do. Thinking that, again, I harp back to the fact that she probably thought there was no reason for her not to think that the
Yep.
binding death benefit nomination was in place and was valid.
Yep. That's right.
And of course, she's not going to be able to rectify that once she's gone. But then when this situation occurs, it's like, well, when was it 2021 to 2024?
Mm.
You think that it's just going to be a smooth thing, and I suppose in the scheme of things, a 3 year sort of argy bargy contest is probably fairly reasonable in
Mm.
terms of a time
It's
frame,
not too
not
bad.
not
Yep.
extending too far into the future. But yeah, I mean, she would have thought that it's a breeze, and what's the big issue? It'll be dealt with. I've got these things in place, and we dealt with at least in 12 months. But even then, 12 months in the scheme of things, particularly when it comes to SMSF death benefit payments and that sort of thing, and potentially the winding up of a fund, that 12 months just goes so quickly, you
It
know?
does go so quickly. And to your point of what's as soon as practicably, well, what is practicable? So as an example, if you wanted to wind up a super fund sort of right now and it had some share investments in it, and then you had the situation of a dividend was paid, then you're like, right, well, the fund's eligible for some franking credits. So you've always got this sort of ongoing consideration with funds. Plus, if so, say you've got multiple members in a fund and one of them dies, as at 30 June 2024, you might not even know the balances because you're still waiting on tax reporting coming through from investments. So at best, you might have 30 June 2023 sitting there, but that's nearly 18 months old now. So how like that this practical side of things, it does make it challenging. And so even if you were to pay out benefits today, think, yep, I've done really well trying to nail what the components might be and what it's worth, etc. There's generally always leftovers that need to come through. And so the practicality of paying people out of a self-managed fund can be a challenge. And so again, getting people into them is reasonably straightforward these days, even with SuperStream. But moving people out of them is the challenge to really be able to land on what their account might be worth. So, and that's also, and again, I'm digressing a little bit here. We often get asked the questions, should I get my kids to join the fund? Now, I'm not a massive fan of that. Where it does work is if the person is quite elderly and they want, say, a farming property that's being used by one of the children in the farming enterprise to remain there. And so, bringing them in perhaps to try and absorb some of that value, I can see how that works. But we had encountered one where it was dad and the three kids. Dad died. The three kids were all in their 40s. And often, if it's mum and dad in there, and mum or dad dies and you've got to pay an amount out of super, if you overshoot the landing, it doesn't really matter because you just take it from mum's account from that perspective. But if you overshoot the landing when you've got 75-year-old dad and kids in their 40s, then that's an ineligible payment that's come out. So how do you treat that? Like all that sort of stuff. So you always, you know, have those leftovers that you need to be mindful of as things progress. Now, I don't want to say, self-managed funds are awful on this front because we obviously love them. That's why we're here. And they're amazing for many other reasons, but it's just being aware of, again, that practical side of things in winding up a fund, perhaps, and even paying out death benefits.
Well, Gemma, it would seem that the more of the technical people that I speak to, the more I'm finding that none of you like having children in an SMSF. And I
It's up
will
there with
again,
the individual trustees. Like, why would you have individual trustees? And also, oh,
yeah,
don't put your kids in
true.
there.
But again, I will say that if my mum's listening to this, don't worry because I know I'm a child and I'm a part of your SMSF and it'll be okay.
So,
I'll be the
shh.
outlier. Okay,
Yeah,
it's
the outlier.
not
Yeah.
I'm atypical of these cases that turn into nightmares. Promise. Any
The other thing with this, so again, you made the point earlier, she was probably entirely comfortable with, I've got my will, I've got a binding death benefit nomination. I've thought about incorporating Mr. Bone into my will. So he gets $1 million, a car, and a life interest in a house. So he's going to be sweet. But then obviously the wheels come off and all of this happens. The binding nomination isn't valid, et cetera, et cetera, et cetera. So the other thing and we encounter that, how is your super being dealt with on death? Are the pensions reversionary? Oh, yes, they are. Are they really? Do you have the actual pension documents that say that? Do you have a binding death benefit nomination? Who does it leave it to? All of those sorts of things. Oh, I'm sorted. It's all covered in my will. So that is a scary, nothing's more frightening than the mask from that Scream movie and someone saying that to me. So it's like, let's double check all of that. And the other thing is, if someone's lost capacity, then unless you go down the path of perhaps getting a statutory will, which there isn't an enormous amount of precedent for that, and each state has their own provisions there. The other consideration is so someone's lost capacity, so they can't execute a new will. Can the power of attorney execute a new binding death benefit nomination on behalf of that person, particularly if it's expired or if it wasn't binding because it wasn't executed properly? Now, I'm from WA. We like to do things a little bit differently. And you can't, if the power of attorney is unable to execute a binding death benefit nomination on behalf of the donor of the EPA or even extend one. And that's because it's considered to be a testamentary disposition, and that's something that a power of attorney can't do. However, in Queensland, you are able to, the power of attorney can do that, provided there's no conflict. So we had the Narriman case where that was
yeah.
tested initially, and then one more recently, I want to say Bella Health, but I think that's incorrect. It could be the Williams or Dawson one. Anyway, there was Rentis, sorry, was the one that it was. So in that one, the power of attorney was the brother, and he was able to sort of endorse the continuation or to make sure that it continued on. So again, Queensland and WA have different provisions about the role of the power of attorney. So again, being aware of how that all works, but it just keeps adding to the different fingers in the pie, or different pieces of pie that you need to be mindful of how they all interact.
100%. Jim, that was a perfect segue to make a reference to Star Wars, not the mask. I would say it would be like when Luke Skywalker and Han Solo took their stormtrooper helmets off, and
Oh yeah, there you go.
they
There you
appeared
go.
to be not what they were because they were
Damn it.
the two heroes. But that's all right.
Oh yeah, they were the two
I
heroes. Yeah.
threw it in there. I got it in there.
Yeah, we got there. We still got it in. We still got it in.
Exactly. We still got it in there. Anyway,
Important, important.
so are there any sort of other things that we haven't unpacked that the case really highlighted there?
So I think the other one was the importance of this claim staking process. So Mr. Heesh went through this and it looked like substantially. So obviously had Mr. Bone, who made a submission saying 100% should be paid to him. One of the justifications for that was, well, he was a tax dependent, so it would all be then more tax effective for the family. Now I fail to see how Mr. Bone getting all of the super was tax effective for her family when they wouldn't get anything, even when he died. But anyway, so that was the consideration there. And there's some other cases that were cited in here that are quite interesting, talking about like the discretion exercised by the trustee. Well, firstly, you don't have to show all your reasons for doing that. The other thing with that is it's not unreasonable for, say, the the tax dependent to receive all of those benefits because of the tax planning element to it. Likewise, it's not unreasonable for amounts to go to the estate. So it's not saying, look, if you're a spouse, you'll always take precedence over other people in that exercise of discretion. But it does highlight that how important that claim staking process is to go through, where you don't have a binding death benefit nomination or a valid death benefit rule or the like sitting in there. And that was highlighted by that Marcella case that came out a few years ago, where the that was it. Did you exercise your discretion in a fair and reasonable manner? So that's all. You know, when you transplant that back to that role of the trustee and what they're doing, are they fairly and reasonably factoring in any potential beneficiary? And then if you look at ours, which was a family trust one, where it was all about, well, how could you possibly have factored in all the potential beneficiaries when you decided on that annual trust distribution, when you didn't even know what two of the kids were doing because you were highly estranged from them? So these days, you can jump on the internet and Facebook, or, what are the kids using these days? TikTok or Snapchat or something, and see what people are up to. But in the context of this one, how could you possibly have decided that Darin didn't need the money or not to exercise the discretion of that annual distribution in favor of Darin because you didn't even know that what he was doing or how he was at all whatsoever. So it's just being, that awareness. And so even though you don't have to justify your reasons, what the process for the trustee might need to sort of list what that looks like. Look, I've assessed Darin. He's doing fine. He doesn't need any money, but I've assessed this person and, Jemma's really struggling. So let's give her some more, or we'll give it all to her. We'll go and look at, I don't know, you like Peter Burgess. So Burjo, yeah, he's doing great. So we won't give any to him, but then maybe we'll go down and give some more to Scott because he needs to buy some more champagne and he's really running low. I don't know. I'm making stuff up now.
A new pair of shoes, probably.
Yeah, new pair of shoes. So, it's those sorts of considerations. It's the requirement to have considered them, but you don't have to treat them equally or do anything like that, but you've got to exercise that discretion in a fair and reasonable manner. So that was an interesting one coming through. And you can see again when you read through and look at, well, the role of Mr. Heesh as that trustee and his time that he spent going through that process was comprehensive. So, but you wouldn't want to be that called to task as part of this to say, well, when you decided to give Mr. Bone a third and the balance to the estate, then you didn't really undertake that in an appropriate manner. So we really need to, be more careful from that perspective.
And of course, it's so important, like you said, to actually go through that process in a thorough manner because
Mm.
otherwise you just open yourself up to potentially another court challenge
Yeah.
because whoever the aggrieved parties were that didn't think that they got enough out of the settlement will then cite that fact that, well, hang on a minute, this bloke doesn't seem to have taken into account, a lot of the personal circumstances or the extenuating circumstances that are occurring here, and he just did that. I mean, with Mr. Bone, it was kind of like, yeah, nice try, but no cigar, mate. With the
The other,
plate that he made. But imagine if you just accepted that. Uh,
yeah,
It's all right, Gemma. I do this for a living. I'm an estate lawyer.
yes,
Well, of course I'd know what I'm talking about. How dare you
yeah.
question my motives wouldn't be on the up and up. I'm a professional. Come on, you
Well, I
know.
think the other consideration with this is, um, so he ran the argument also that they were in a de facto relationship. So that's one element that you need to have a look at, because under the super legislation, only cis dependents, which includes a spouse, and a spouse can be a de facto, or the LPR, i.e., the estate, can receive the money. So sometimes the rather than having the fund subject to a dispute and the estate subject to a dispute, do you just pay it all to the estate and then be like, well, I considered it, and but you still have to demonstrate that you did appropriately consider it in that context. But because that's the thing, otherwise you're running like concurrent disputes, because if the 2/3 going to the estate you didn't consider it was enough because you got your third plus you're getting your million and a life interest, is it less of a are you less likely to get a higher award by disputing the estate as opposed to saying you didn't, because this has got such a narrow eligible beneficiary? So again, you've got those considerations coming through. So I'm just mindful of time because, of course, we digress very easily.
Yep,
Lots
no.
of lessons to take away from this particular case, and I think it just serves to again highlight how important all that documentation is, and the consideration, the practical. Okay, so yes, your husband's died, and of course that's very sad. And now it's just you. What next? Like, what happens? What's going to happen then when you die? And even before that, even if you've got a husband and wife, or I'm referring to that nuclear sort of family, even if you've got them there, well, what if they both die in the same car accident? So then
Mm.
who is stepping in to deal with that? Does your death benefit nomination, is it valid and binding? Do all those deeds, that chain of deeds, do they all match up? Like that sort of a comprehensive, I think I've referred to it like that health check on, uh, it might be, well, the content of the nomination and who you want to leave your money to is one thing, but is it valid? And what if you were to die today, where would stuff actually go based on, and who would be in control of things based on how everything looks right now? And I think that is an area that some people may not appreciate, or what they think is happening because my will's dealing with it. I've got a binding inverted commas death benefit nomination, etc. There's a lot of elements here to that we can learn from.
Yep, well put, Gemma. And of course, that's why we discussed the Gainer case in the first place.
Mm.
So that, as Gemma mentioned, we're out of time again because, as she said, we can talk about this stuff for hours, and we probably didn't
Yes,
even
we
touch
can.
on half of the stuff that we wanted to, as far as the Gainer case goes. But that is our discussion of the Gainer case. We hope you found that informative. So many SMSF issues addressed by that court decision and by those set of circumstances. So, other than that, I'd just like to thank Gemma for joining me today in presenting the podcast. Thanks, Gemma. And again, it was great to see you.
Thanks, Darin. Always a pleasure to chat about this sort of stuff.
And thanks to my production team behind the scenes who put this together and posted on all of the different platforms where you can access this podcast. Don't forget, if you're enjoying this on YouTube, please smash that like button and subscribe to the channel. Other than that, we thank you for your company. We hope you enjoyed listening to this podcast as much as we enjoyed presenting it to you. And we look forward to your company again next time we do a cross country super podcast. Have a great day, travel safely, and bye for now.